Media related acts were made on two major domains. The first one is related to the government and government agencies with regard to how the government was trying to control the media in different forms and how the government was trying to control the media in the form of enacting laws related to the judiciary, the parliament and the governance. So, these were the areas in which the laws were enacted during the last 70 years. We have tried to understand that how that was enacted in the last 70 years. With related to press, we will see at least 10 case studies of acts, so that we can understand that what kind of acts were enacted in the India since 1867. Probably 1867 was the first act that is related to Press and Registration of Books Act 1867 and followed by the Registration of Newspaper Rules 1957. This was the initial act that aimed to control. During the British period, the aim was to take into account all the documents related to, all the information related to printing of books and registration of books, newspapers also. Actually, after the first initial Press and Registration of Books Act 1867, the new act, the Cinematography Act 1952. Cinematography Act is one such thing that tried to facilitate the certification of films produced in India. That act make provision for the certification of cinematographic films for exhibition and for regulating exhibitions by means of cinematograph. Whatever that is being produced in the form of cinematography, that is being regulated through this. So, the act facilitated the establishment of the Board of Film Certification, now the popularly called as Censor Board, that is being facilitated through this particular act. And the act says that the board shall consist of a chairman and 12 to 25 members in its board, so that this can regulate. The act also deals about the examination of films, advisory panels for the commission and certification of films, appeals, how one can go for appeal to the higher ups and how appellate tribunal should be constituted, and further the act also discusses about suspension and revocation of certificate and review of orders by the central government. Whatever the government is being given to the regulation of films related act, this act gives a idea. If you look at the third act, that is Drugs and Magic Remedies Objectionable Advertisements Act 1954. Right immediately after the independence, we have been trying to regulate the system of media in all domains. We saw that press and newspapers are regulated, then cinematography is regulated. We want to control the advertisement also. So, the drugs and magic remedies. Remedy should be procedural, clinical and step by step. Control the dubious and fake advertisements that is being claimed in the name of medicine and other thing. So, the act deals with the prohibition of advertisement of creation of drugs for treatment of certain diseases and disorders. Prohibition of misleading advertisement relating to drugs also being controlled here. Prohibition of advertisement of magic remedies for treatment of certain diseases and disorders. Prohibition of import into and export from India of certain advertisements. Penalty also, what kind of penalty can be given if there is a dubious and fake kind of advertisement is being released. Then the major area in which we had enacted was Working Journalist Act. Actually, this was also in earlier, immediately after the independence, that was 1955. We enacted the Working Journalist and other newspaper employees conditions of services and miscellaneous provisions act 1955. This is the first act. Actually, there were lot of private, we saw in the earlier slides that was the only area where the private operators were allowed, because radio and television was in the control of government until 1990. So, this area they wanted to have facilitate the wages, facilitate the minimum conditions for both journalists as well as non-journalists. And in one particular section called section 9 and section 13C of the act provide for constitution of two wage boards separately, one for the working journalist and the other for the non-working journalist. So, non-journalist and newspaper employees, so that is a two wage board have been recommended by this particular act. And the central government shall and when necessary constitute wage boards which shall consist of 3% representing the employees in relation to newspaper establishment. 3% should be come from the newspapers and 3% representing the wage boards and 3 from representing non-journalists. So, 3 from newspaper family and 3 from journalist family, 3 from non-journalist, and 4 independent persons, one of whom shall be a judge of a high court or supreme court, who shall be normally the chairman of the committee. So, wage boards have been periodically constituted and they have been recommending to the government accepts the wage boards. So, the salary level of journalists is being constantly regulated and maintained on par with any international standards. So, next is about the Prasar Bharati Act. Prasar Bharati Act 1990, this deals with the deregulation of the radio and television, because until 1990 the radio was the monopoly of the government of India and television, Doordarshan, was the monopoly and the control of government of India. So, we wanted to free the airwaves. So, the Prasar Bharati Corporation was instituted, that was given, even the government take over the control or the managing of the radio by government and television by government has been given to an independent corporation called Prasar Bharati. The Prasar Bharati Broadcasting Corporation of India was actually constituted on 23rd November 1997. So, the bill was passed in 1990. It took about 7 years for the government to constitute the Prasar Bharati. It is a body corporate, and the act also talks about establishment of Broadcasting Council. Actually, every act is talking about establishing some kind of mechanism that will helpful to the government to regulate the agency. We saw that Film Censor Board was constituted by the Cinematography Act. The same way, this particular act, Prasar Bharati Act, suggests the government to form the Broadcasting Council that will take care of the entire broadcasting domain of this country, be it private or be it public or be it government owned. All these things are being governed by this particular Broadcasting Council. Now, we move on to the next act called the Cable Television Network Regulation Act of 1995. So, these are all come after the 90s Prasar Bharati enactment. This act regulates the operation of cable television networks in the country and the form matters related to that. No person shall operate a cable television network unless it is registered as a cable operator under this act. The central government may specify the names of Doordarshan channels or the channels operated by on behalf of the parliament, something like Rajya Sabha TV and Lok Sabha TV, to be mandatorily carried by the operators of the cable services. And we move on to the next, the very important act is 1997 TRI Act, Telecom Regulatory Authority of India Act. This was actually Telecom Regulatory Authority of India take care of phones, internet and television channels and other things, even radio also. They take care of the entire domain of the communication channels. This act provide for the establishment of the Telecom Regulatory Authority of India and the Telecom Dispute Settlement and Appellate Tribunal. So, it not only to set up the TRI, it also recommended to form the Telecom Dispute Settlement and Appellate Tribunal to regulate the telecom services, adjudicate disputes, dispose of appeals and to protect the interest of service providers and consumers of telecom sector, to promote and ensure orderly growth of telecom sector and for matters connected with that. The Act provides details related to the establishment of authority, terms of office, conditions of service and the appointment of chairperson and other members to the committee, and what will be the powers of the chairman and the vice chairman of the committee. Also, whenever this kind of acts are enacted, it also spells out how the office should be removed, how the office of the chairman should be removed, how to suspend them or how to revoke the suspension or other thing, and powers and functions of authority. What will be the powers and functions of the Telecom Regulatory Authority, and establishment an appellate tribunal. Normally that when there is a dispute, then they have to go for appellate instead of going to the courts. So, all acts of enabling the settlement of or the setup of appellates, and what is the procedure and the powers of the appellate tribunal, and how the finance and accounts of the entire TRI will be controlled and managed, who will be the financial controller there. So, these many things are being given in the TRI Act. We will shift to the next, to the Information Technology Act 2000. Information technology was taking up in all domains at the convergent take place at every level. So, we need to go for a convergent act called Information Technology Act. This act provides legal recognition for transaction carried out by means of electronic data interchange and other means of electronic communication. All forms of electronic communication are taken place and being regulated through this particular act. The General Assembly of UN by resolution of 1997 adopted the model law of e-commerce adopted by the UN Commission on International Trade Law. So, the resolution recommends that all states give favorable consideration to the model law when they enact or revise their laws in view of the need for uniformity of the law applicable to alternatives to paper based methods of communication and storage of information. And so, based on the UN model law, the Government of India enacted a law called IT Act 2000, and it necessary to give effect to the UN resolution and to promote efficient delivery of government services by means of reliable electronic records. The Right to Information Act 2005 is a very significant act with regard to empowering the citizens of India with regard to the accountability and to enabling transparency in the governance of the government. Actually, this was a central act influenced by the UN recommendations, and we enacted in 2005. The act says that there should be a central information commissioner at the national level and a state information commissioner at the state level. So, every state should have the state information commissioner, and at the national level there will be a central information commissioner to take care of the grievances and to take care of the challenges and the requests received from the public with regard to right to information. This act justifies the need to have an act in the Democratic Republic of India. Democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governance and their instrumentalities accountable to the government. It further argues that the revelation of information is actual practices likely to conflict with other public interest, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of the sensitive information. Hence, it is necessary to harmonize these conflicting interests while preserving the paramountancy of the democratic ideal. So, it is expedient to provide for the functioning, furnishing certain information to the citizen who decide to have it. So, the act talks about obligation of the public authorities, what the public authority has to do, how they have to be accountable and answerable, and the act also talks about establishment of central information commissioner and the state level of information commissions. And it talks elaborately about the powers and the functions of the information commissioners and agencies that are excluded from this. Actually, there is a schedule called Schedule 2, which has a long list of central agencies called security agencies and intelligence agencies, which cannot come under the purview of this particular act. Now, we move on to the final list of this particular act, this list we have been discussing, that talks about the DTH Act. The act name is the Direct to Home Broadcasting Services Standards of Quality of Services and Redressal of Grievances, Regulation Act 2007. The act facilitates that every direct to home operator shall, on fulfillment of the requisite requirements for providing direct to home service, provide on non-discriminatory basis the direct to home service to every person making request for the same, subject to technical and operational feasibility. That is a legal word. The meaning is that everyone should be given the DTH facility. If you are demanding something, then irrespective of your caste or creed, irrespective of your political position or irrespective of economic position, you should be given the access to the broadcast of direct to home services. The act further talks about the procedure for direct to home service connection, disconnection and shifting, and billing or direct to home service, how to bill it. Is there a very transparent method, and is there a reasonable method by which the billing can be done, and the redressal mechanism also of the grievances being raised by the direct to home thing. So, in this module on media related laws in India, we discussed about the context in which the different laws were made during the last 70 years. Then we moved on to understand the different kinds of lawmaking with a case study of 10 laws, right from the 1867 Newspaper Registration Act till the DTH Act passed in the recent times. We also saw about Working Journalists Act, we saw something like RTI Act, and these many acts were given a larger idea about how the media related acts are being created to facilitate the information flow and access to information. Hope this lecture would given you some idea about understanding the lawmaking related to media. Thank you for watching.